And let's see. That first.
Did that 9:30 pre-trial go yesterday, Judge? Lincoln?
I don't remember. Later.
Good morning.
Good morning. Are we expecting anyone else on Gatehouse?
No, Your
Okay.
Honor.
Your Honor.
Shannon, put us on the record, please. Okay, Gatehouse Media versus Nicole Hawkins et al. Counsel, state your appearances, please.
Michelle Harrell, appearing for plaintiff.
Ron Marienfeld on behalf of the defendants.
And Ms. Harrell, this is your motion.
Yes, Your Honor. So today is our motion for contempt and related relief regarding our prior motion to compel and the order entered by the court. This started out as mostly a collection case. And then there was a counterclaim brought that sought lost profits, damages, exemplary damages, relating to supposedly our failure to provide advertising correctly that resulted in damages to the counter defendants. So we filed a motion in January. The court issued an order compelling discovery, and this discovery was actually due. It was, this case has been pending a long time. It's been due for more than a year. And we were very specific what we were seeking in the order compelling the discovery, focusing on their counterclaim really for their lost profits and exemplary damages. And since that time, we have been in a pattern with the counter defendants. So before we filed our motion to compel, we asked them to produce the documents. We thought their responses were deficient. They ignored us. We filed the motion. We kind of ignored the motion until right before the hearing and then produced more records that should have been originally produced. But then the order was entered. They had 14 days to respond again. And at that time, we kept prompting them saying, we haven't received anything. The deadline's expiring. We were ignored there. Then right before the hearing, we get a flurry of things again, more documents, just random things dumped on us. There's no rhyme or reason to them. And in fact, the response to this motion wasn't even provided to us until yesterday afternoon late. And looking at what was produced, they're not in compliance with the court order. I've litigated dozens of these lost profit cases over the last 30 years. And this is their claim. This isn't us trying to harass them based on our case. But for example, interrogatory 26 asked them to itemize and explain their supposed damages on their counterclaim. Well, they gave some general description and then they say, see attached. Whatever that means, I don't know. It doesn't describe the documents. It doesn't describe how it's computed. It says approximately 33,000 of one thing, approximately 156,000 of something else. So that's not responsive. And that was after the motion to compel and the order compelling. And they continue to trickle out documents to us. So usually in a lost profits case, what I'm used to seeing, and probably what the court's used to seeing, and maybe Ron has used, are tax returns, projections, something showing where this lost profits are supposedly coming from. So we've been getting random tax returns, and suddenly we got some tax returns, some documents on an entity called MVP Sales, which is not even a party to this case. We haven't heard of this entity before, but suddenly we're getting documents for them. And there's just this ongoing pattern. There's a court rule requirement that they designate the documents according to the requests that they're responding to, and we can't make rhyme or reason out of what they're doing. So, but with all that aside, the order was very specific. It said full and complete responses to interrogatory 26, request for production 1 through 5 and 10 through 18. And that has not been done. And this is just an ongoing pattern of evasion by counter defendants. These are not new documents, and they continue to just sort of trickle in just in some random fashion. And I just want to take a moment to talk about the concept that we are litigious and we want to be in front of your honor. We just want to file motions and they're frivolous. Council Marienfeld wrote in his response that he wants sanctions against us because we just repetitively file motions. Your Honor, there was a counter complaint filed in this case, and one of the counter defendants was Nicole Hawkins. And I took her deposition and I asked her why she had a counterclaim. At first, she acted like she didn't even know. And Council Marienfeld said, she's not a counter defendant. But when we pulled out the counter complaint, sure enough, she's a counter defendant. Well, he should have.
You mean a counter plaintiff?
She's no longer a counter plaintiff because we filed a motion to dismiss her. Again, that was ignored until right before. And we asked him to pay the cost for filing that motion in the first place. Council Marienfeld did not want to do that. But instead of arguing that motion and going through that whole thing, which if we were litigious, we would have done that because we incurred costs for that, we stipulated to just dismiss her from the counterclaim, which should have never been filed in the first place. So this whole case has been a pattern of this, Your Honor. I mean, I don't lightly file motions for contempt and asking for a counterclaim to be dismissed. But this case has been pending for more than a year. We think we've been more than reasonable trying to get this information. So we're asking the counterclaim be dismissed. And if the court's not inclined to do that, we ask that you maybe allow him 5 more days to comply. And if he does not, then the counterclaim would be dismissed because time is up. And there's no reason that we keep going around and around on this. And because we have filed motions and we have incurred expense, not only for this, but for being back in court, we're asking for our attorney's fees today for this motion. We think that may motivate them to pay more attention to what's going on and to honor what the court orders. That's all I have, Your Honor. Thank you.
Morning, Your Honor.
Marienfeld?
One thing I would agree with, we're definitely in a pattern here. And it's put into a case, it's pretty typical of some East Side firms. But I want to go back to reality and what happened after the last hearing. We did issue an order. We did produce documents and individually tabbed. This was the first set of documents that went out. Again, same response comes back. We're not happy with your answers. We don't like the answers. We don't understand them. We want more. So we come back and I go back to my clients the other day before this hearing. Say, is there anything you possibly didn't produce? This is the list with the specific questions. Then they come up with another smaller stack, I would admit, of some emails that really, like they asked me, what does this have to do with this case? They produced them anyway. All the tax returns. And this is, I think, where we have part of the problem here. And it's not my problem, not my client's problem. There are 2 sets of tax returns. There are 2 auto dealerships involved in this case. They have several, I'll call them mini entities, names that they use to get warranties, different information, put their name out there. But each different entity or Google name they use, they don't file a tax return for. They have 2 companies. If you read the tax returns, within those returns show the numbers they're looking for. The MVP information, they could ask. If you read down in the tax returns, that's the name of one of the corporations. I can't help they didn't sue that corporation and didn't figure that out before. That's not a shocker, something they surprised them on. The reason it's not there, one of the corporations never even did business with the plaintiffs. And that answer, they just don't accept. They don't like the answers. They want a document to be out there that says, you guys, CR Motors, you stole Hawkins, so you could come work for her and we could give your business to a competitor. This was our goal here. That email's not out there. It doesn't matter what we send them, it's not gonna be there. And I don't know what else we can produce. If there are things, I asked the other day, said, sent to the other attorney. There's two attorneys that we work back and forth. Rachel Crawley, I sent an email and said, what is it you are specifically looking for? I'd be happy to go myself and look for it, see what this is. The answer was read my brief, read my motion. So we were going to be here regardless. They dismissed the other motion because there was nothing to it. Weren't going to award sanctions. This was the fallback. They want you to award sanctions because the more depositions they take, the case is falling apart, and this is the only money that they may get out of it. The person that could answer their questions, the one deposition they keep canceling, they have all the documents to take every other Hawkins deposition, other employees' depositions. But the one guy, Sam Jones, who could answer all the questions, explain the tax returns, explain that they don't have a contract with every single vendor that they deal with. These are people that have been in business a long time, working with the same people a long time until this situation came up. Some things are on a handshake. I've told them there isn't a contract for that, but you know what? There's an email that talks about it. We sent them to just what that's worth. So if you think we're playing dirty and hiding some mystery document, I'll pay the sanctions that you order. That's fine, but I don't think it's warranted. And if you want to give them 5 days, I don't know what I can produce in 5 days. If there's some specifics, and after this last two reams of documents we've sent over there, and I can't make them understand the documents. You can produce them. So, yeah.
So Mr. Marienfeld, one of her complaints is that instead of telling her which documents in the stack of documents you produce are responsive to which document request or interrogatory, all you said was, see the documents. That's insufficient. You have to specify which documents are responsive to which requests. You must do that. You can't just say, look at this big stack of documents. They're entitled to know what specifically you are relying on to prove your damages. And if you're telling me you've given them everything you've got, that's fine. You can't give them something you don't have. I get that, but you got to at least tell them which of the documents you gave them is responsive to which request, which interrogatory, which document request. You got to do that. That's essential. Now, how did you bait stamp the documents you produced?
No, we wanted to get them quickly because all we were told is time is of the essence. So we broke them down, as you can see, separated them. It wasn't just a stack of documents. These are all individually sorted out, including the tax returns, the way they come to us from the accountant. And we emailed most things to get them there as soon as we can. If I have no problem. We had a specific request, just as she said. We wanted whatever numbers she pointed out, 10, 15, 26, 23. There were like 4 or 5. I thought when I provided the documents, that's what we were talking about, is those 5 questions. If I have to put in there that the email that I've attached was sent from this person on this date, which it all says on the document, and this is responsive to question number 23, I can do that. Never had to do that, but that's fine if that's what we need to do. But I'll do what the
Well, that's
court.
the way you should be doing it. In fact, what good practice is, when you do produce documents, you bait stamp them by number, so that when you're responding, you can say, look at this page number X through Y, whatever it happens to be. So it's specific. I think you need to do that. I think you need to take the documents that you've already produced. You need to bait stamp them, however you do that. I used to do it with the copy machine. It was pretty effective. It'll just add.
I understand how to do it, Judge. I just didn't realize you needed to do it when you have an email that has a date and a name. I understand it. And I will go back and do that, but I would like to be clear so we're not back here tomorrow. Would you like me to email these, mail them, FedEx? How would we do it so we don't have more requests, more complaints?
I can't order you to exchange by email. You can stipulate to that. What I can order you to do is within 7 days of today's date, that means by next Friday by 5 p.m., you must put in the mail and email a specific response to each of the identified requests that were in the court's last order, which documents are responsive to which requests. You must do that. That's critical. If you don't do that, when a follow-up request is made to dismiss the counterclaim, I'm going to be really, really receptive to that. Whatever you produce, you will not, absolutely under any circumstances, be able to show up at a trial or respond to a motion with any document that was requested and was not produced. So I hope that's really clear.
It's pretty clear, Your Honor. It doesn't work both ways, but it is pretty clear. I haven't had a bait stamp document yet, but that's fine, Your Honor. I will go back and follow the order.
All of our records have been bait stamped. And
All right. Well, I've only got one motion in front of me today. Mr. Marienfeld, if you're upset with discovery that you've been provided, you have the option of filing a discovery.
Thank you, Your Honor.
I am going to award a sanction of $500 for the necessity of having to bring this motion. And the items need to be, your responses need to be supplemented, and the bait stamped documents so she knows which ones you're referring to. And I realize you're going to be producing the same documents again. I get that.
This is the
But this
third
time
time.
there will be a specific page reference on them. And don't try to introduce anything else that you have not produced in response to these requests.
No problem, Your Honor.
Ms. Harold, you prepare that order?
yes, Your Honor, thank you.
You're welcome. Have a good day.
Thank you. You too.
So are you familiar with the term bait stamp?
Yes.
There actually used to be a stamping device. It was called a Bates. That's a company that made it. And each time you stamped, it would cycle to the next number. So before we had, plain paper copiers that we could run things through and add page numbers at the bottom to them, we had to use this bait stamp, and you could set it. So like, say you were marking 5 sets of documents, you could set it so that it would cycle on every 5th click. So the first document would be 00001, and you could do it 5 pages, and then you go to the next one, 00002. I never did it with more than 2, but it was painstaking work. It's so much easier. Whenever I produced discovery, I did it. Because it was easier. It was easier to refer. So when you're doing depositions, instead of remarking every deposition you've got, every exhibit you want to question about, you just refer to the bait stamp. It's just so much easier to do it that way, especially when you got a lot of documents. When you don't have a lot, it doesn't matter, but definitely. All right, let's see. Get Mr. Rick in here. And I'm gonna guess. Let's see. I think I just let somebody in with a telephone number ending in 4519. What is your name?
My name is James Weidman.
Oh, okay. Well, then you're in the right place.
Okay.
The name with your screens. Okay, and then I've also got James iPad. Is that also you?
That is also me. Yes, sir.
All right, well, I'll bring that in too. Maybe we'll be able to see you then. All right. Looks like you're here twice. I don't see an image, but. Okay, this is Baja Asset Management LLC and Clark Lake Capital LLC versus James Weideman and Progressive Holdings Group. Mr. Rick on behalf of the plaintiff, Mr. Weidman in co-per. Okay. And I've got a Brian Root in the waiting room. Is that a name familiar to you?
Yes, he's a member of the plaintiff's, Your Honor.
All right, all right, we're getting some feedback here. All right, Mr. Weidman, I muted your phone because we were getting feedback.
Okay.
Can you hear me? Can you hear me through the iPad?
Yes, I can.
All right, well, good. That solves the problem. And I'm sorry, Mr. Rick, what is Mr. Root's role here?
Mr. Root is the member of the two plaintiff LLCs.
Oh, okay. That's Brian Root, R-O-O-T. Okay, this is plaintiff's motion for a default judgment. Go ahead, Mr. Rick.
Your Honor, we filed this complaint back in August of 2020. Served Mr. Weideman individually and also Progressive Holdings Group LLC. There's been no answer filed, no response of pleading of any kind. This is the first response, his presence on this call this morning, that we've received in response to the complaint. The defaults of both defendants have been entered, and so we're seeking a default judgment to be entered.
All right, and this is a complaint for money damages. What's the underlying claim, counsel?
This is a complaint for both money damages and also to quiet title to real property. The transaction involved fraudulent representations by the defendants as to their authority to act for an LLC called Roxton Group. In reliance upon the representations, the plaintiff, Baja, deeded some property to Progressive Holdings and also gave them some cash. Since learned that those representations were fraudulent, and as a result, they've lost title in part to the LLC, to the real property owned by the LLC, and also have paid cash, which they should not have because it was fraudulent to request it.
Okay, Mr. Weidman, you understand that you and your LLC are in default in this litigation? Do you understand what that is?
I understand what that is. And what I would like to do this morning, because this has been an ongoing matter for a couple of years now. First and foremost, before this proceeding is completed, I would like to request.
Let me stop you for just a minute. I see somebody else is logged in. I don't have anything else scheduled till 10. So I've got a Larry Opalewski. Do either of you recognize that name?
No.
All right, well, we'll just leave him
Am
out.
I on there, Jen?
Mm-hmm.
I'm sorry,
Okay.
sir. Go ahead.
Okay, so this matter has been going on for a couple of years now. And from the onset of it, the very claim that the plaintiff, his attorney, and their entire side, the entire claim is baseless and is fraudulent. And before we're completed, I would like to request the court to let me know how I may be able to request to set aside the default judgment, because I would like to have legal representation to defend myself and to show the courts that there was never fraud involved on my side. I own my company, and according to the United States IRS, the IRS department can prove this with the letter that I can have from them. And I also have Bank of America can give me a proof and letter as well. Everything that I transacted business with, according to my LLC, which is Roxton Group LLC, I own the company. I own the intellectual property of the company. there was a person that worked with me within Roxton LLC who conspired with the plaintiffs to steal everything I built. They broke in a building, they took everything from me, and they used the law fraudulently, wrongfully against me. And all of this is documented. If I had done what they said I did, this would not be a civil case. It would be a criminal matter. If you cannot defraud someone out of property in America, you could do it, but it won't stick. And what I'm willing to prove to you, and I know I can prove this with the proper letters and proof from the government, I own my company. The lady who did this to me, along with Brian Root, they stole everything from me. They used violence. They threatened my life and my family, and they tried to run me out of town. And they took a company that I built. I have been an entrepreneur my entire life. Rick Abbott knows we negotiated a transaction with Brian Root. He was a landlord. He did an illegal eviction. They did a lot of stuff. The police was involved. When I went to the police to give my side of the story, the only thing they told me was, this is civil, it's not criminal. I said, well, no, they entered a property that he should not have ever even entered that property without a 3-day notice. That's in our lease. So if this is a case of them saying that I defrauded them, they will have to go back to the point that I gave them money to lease a space. The plaintiff, go ahead.
So Mr. Weidman, let me interrupt you.
Yes.
So under our court rules, there's very specific guidelines, instructions for how civil cases are handled. They're started by filing a complaint.
Mm-hmm.
That complaint, along with the summons, is served upon the defendants. In this case, you were one of the defendants, and your company, Progressive Holdings Group LLC, was a defendant. In that summons, you were specifically told that if you wanted to defend this case, you need to file an answer to the complaint.
I was in it. Go ahead.
It says right on it, sir, you have 21 days after receiving this summons and a copy of the complaint to file a written answer with the court. You did not do that. Your company did not do that. That's why you're in default. If you wanted to hire an attorney, the time to do it was when you got the complaint.
I could not do it.
Well, I can't help that, sir. Not only do you have to follow the rules, wait a minute, I want you to listen to me. Not only do you have to follow the rules, I have to follow the rules. I took an oath to follow those rules. There's procedures when you're in default to even seek setting aside the default. But that's incumbent upon you to do that. And I'm sorry, I understand you're not a lawyer, but you know what? The same rules apply to everybody, whether you have a lawyer or not. You have to follow those rules, and I have to follow those rules. You did not do that. You are in default.
Medical reasons also, sir. For for medical reasons, do those rules still apply as well? Because my attorney can.
Absolutely. If someone for medical reasons can't file an answer within the time frame, they can request the court an extension of time for additional time to file an answer. And if there's good cause, I'll consider that. And even if there's good cause after the fact that you didn't do it, I can consider that. But you got to follow the rules. You haven't done it. You can't just show up on the day that the plaintiffs are asking for a default judgment because of your default entry and tell me, well, you shouldn't do this, Your Honor. The court rules say explicitly what you must do, and you are charged with knowledge of those court rules, just as I am charged with knowledge of those court rules. So I appreciate where you're coming from, sir. I can't hear this today. I can't hear because it's not properly in front of me. Mr. Rick, you are entitled to a default judgment. I'm going to grant it. Mr. Weidman, I can only tell you, the best thing you could do is talk to an attorney and find out what, if anything, you can do at this point for any kind of relief. But I have no choice. I have to follow the law. I have to follow the rules. I have to enter this judgment today, and I'm going to do that.
Okay, well, I'll
Mr.
definitely
Rick.
have an attorney to help me on this because that's all I came here to do. I didn't come here to receive your default judgment because it's fraudulent. And if they want to do that, that's fine. But I'll have representation.
All right,
But
Peter,
this-
would you- All right, that concludes our hearing. Thank you.
Thank you, Your Honor.
This is so bad. This is just ridiculous. Fraud.